Mr. Jones, I'm going to tell you Mr. Jones, I'm going to tell you
I'm not allowed to object. I'm my own counsel now. I'm allowed to object, ain't I? It's only 3 years.
When I'm talking, you do not talk over me. Do you understand that? Because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
It's 3 years. I don't need
Mr. Jones, I don't care what you want with regard to that. I'm following procedure, and this is what we're going to do.
All right, guys, buckle up because this one is wild. We've got a full-blown sovereign citizen sitting in court acting like the law doesn't apply to him. This dude walks in with the confidence of a lawyer, but the logic of a YouTube comment section. He's already serving for years for armed robbery. Somehow he's managed to rack up another 3 for assaulting an officer while in prison. Yeah, you heard that right. He's breaking the law from inside the place built to keep him from breaking the law. You can't make this up. The craziest part is how calm the judge stays through it all, even while this guy keeps spouting absolute nonsense. It's like watching someone try to debate gravity. Wait until you hear what he says next. It's pure delusion. So what do you guys think? Is this guy genuinely brainwashed by sovereign citizen nonsense, or is he just trying to sound smarter than he is? Let me know in the comments. Hit that like button if you're enjoying the breakdown. Let's dive straight into this courtroom meltdown.
Your Honor, my client has indicated to me that he might want to represent himself in this matter. I just wanted to bring it to the court's attention to have the court address that issue.
All right, Mr. Jones, why don't you tell me what's going on?
I just want to represent myself. I feel like nobody's going to fight for me like I'm going to fight for myself. I've been through Waiver, I've been through jury trials. I've done all this before.
Did you go to law school?
No, I did not, sir.
So do you know all of the rules of evidence and the rules of criminal procedure?
I don't think I really need it with this case.
Yes, you do. You absolutely need them because every time something happens, Mr. Arnold here has been a practicing trial attorney with the prosecutor's office in Hamilton County and Warren County for how long, Mr. Arnold?
Well, if you add in military time, almost 46 years.
46 years. He's a skilled trial attorney. He knows the rules of evidence and he knows the rules of procedure. You can roll your eyes at me all you want.
I don't really care about none of that.
But here's the problem. I'm required by my canons that I hold you to the same standard that I hold Mr. Arnold, even though you have no formal training or education in the law.
All right.
I'm sorry?
It will be all right.
It won't be all right. I'm telling you,
That's
you won't.
Man, it ain't no time, bro. I got 10 in, 4 left to do. I do not care at all, even a little bit. It's 3 years. It's cut and dry. What happened, happened. I didn't start this. Let the jury decide. I don't care about none of that, bro. None of the stuff you talking about right now make any sense to me. Do I care about it at all, even a little bit, man? It's 3 extra years max.
So what are you telling me?
I'm telling you, I can represent myself. I can handle it. It's not that serious.
Ms. Martin is a skilled trial attorney.
That's cool. I might be a skilled trial attorney too. Sometimes you gotta try stuff in life and never know how good you might be at that.
You ever picked a jury before?
I have. I've been through mass of those. I've been through at least 7 different ones of those. Some of them didn't go all the way through. People got sick and stuff like that. Had to do it all over again.
You realize that if you do this, you cannot use ineffective assistance of counsel as a grounds for an appeal. It's not a basis for an appeal. You'll be representing yourself. You'll be held to the exact same standards that I hold Mr. Arnold to, and it would be a huge mistake.
All right.
I'm sorry.
Cool.
It's not cool. You're making a huge mistake.
I mean, I made a whole bunch of them. I'm sitting in prison right now for something I ain't do, so I make a lot of mistakes. You can't live life with regret, man. You gotta do what you gotta do.
You've got to be kidding me. This guy's literally out here treating extra prison time like it's a hobby. He's already locked up for aggravated robbery, serving years behind bars, and somehow still acting like he's got nothing to lose. But here's where it gets wild. If the jury finds him guilty this time, it's not just 3 more years on top of his sentence. It's 13 years. Imagine gambling with your own freedom like that, just to prove a point. You watch his attitude in court, and it's almost like he thinks this is a game he can win. Spoiler, he's not winning anything except more time. Still, I've got to ask, do you guys see any way he walks out without that extra sentence? Or is he basically building his own prison extension at this point? Let's dive back in and see how this chaos unfolds.
Well, I'm inclined to decline that request. We are here on the day of jury trial. The jury is waiting for me to bring them down. I'm inclined to allow Ms. Martin to proceed representing you.
I don't want Ms. Martin representing me. I want to represent myself. I don't need somebody that's gonna lay down and work with the prosecution. I'm gonna do what
Miss
I
Martin
gotta do.
does not,
I mean, that's cool. Your opinion is irrelevant in this matter. Your opinion is not helping her none. You work with the prosecution. You ain't here for me.
you are incorrect. I do not work with the prosecution. I do not work with the defense counsel. Actually, one of my functions here is to make sure that your constitutional rights are protected, which is what I'm doing right now.
Tested.
I'm sorry?
That will be tested. We will see about that.
The other problem is, obviously you have a right to remain silent with you asking questions, and you're making a huge mistake.
It's added to the list. It's a whole bunch of them. It's a long list.
Has anyone threatened you in any way or promised you anything in order to get you to waive your right to counsel?
No. Just want to represent myself. I can't go any worse than it might be about to go. It's only 3 years, man. It's only 3 years. I got that.
And as long as you understand that in asking questions, in picking the jury, in everything that you do, here's the other problem. Here's the other problem. Is he in shackles?
Yes.
Okay, there's the other problem. Because you are in custody, you have shackles on. Do you want the jury to see you in shackles?
That's grounds for an appeal by itself. I realize that part. You're not supposed to let the jury see me in shackles, so I mean that's kind of like a tipsy-turvy type of thing right there. I know a little bit more than most. I ain't all the way simple, close to it, but a little bit more than most.
Your Honor, if you're going to entertain this, I think you need a written waiver, A, and a much more detailed, the 12th District, and I can't remember the name of the case, a few years ago, came out with a much more detailed.
All right, we'll go through it. Hang on. All right, Mr. Jones, you've been handed a waiver of right to counsel. You understand that you have the absolute constitutional right to be represented by an attorney. Do you understand that?
Yes, sir.
You understand that you are not being charged for Ms. Martin's services, that you have the right to have an attorney appointed to you free of charge. Do you understand that?
Yes, sir.
And you understand the charge against you is a felony of the 3rd degree assault because of your status, the status of the alleged victim, and the location of the incident being in the Department of Corrections, that the maximum penalty is 36 months in prison.
Correct.
All right. Are you aware of any possible defenses to this charge or this allegation?
Meaning what?
I'm just asking the question. Are you aware of any? Are you aware of any?
I don't understand the question you're asking, sir.
Well, you're going to represent yourself and put on a defense, I assume, at least by way of cross-examining the witnesses presented by the state.
Right.
You understand that?
Yes, sir.
All right. You understand that there may be possible defenses that you could raise in your cross-examination of the state's witnesses or in presentation of witnesses on your own behalf. You understand that?
Like impeaching a witness?
Sir, I'm not going to explain every single thing to you. That's why I'm trying to encourage you to go with counsel here. Do you understand?
Yes, sir.
All right.
This dude seriously does not get it like at all. If he were facing 10 years right now, his reaction would probably be, A, it's just 10 years, like, bro. You only get one life, and 3 years is a huge chunk of it. Think about it, go back just 3 years. Can you even remember everything that's changed since then? That's time you can't get back. And yet he's out here acting like it's nothing. Honestly, it's kind of terrifying watching someone treat the law like it's optional, especially when we're talking about a guy who pulled up to a gas station with a weapon, threatening people like it's just another Tuesday. That's not just reckless, it's unhinged. And the wildest part? He's got a free lawyer literally trying to help him, but he's brushing off the advice like he knows better. I don't know, man. Is this guy just clueless? Or is he really trying to self-destruct on purpose? Let's dive back in and see where this disaster goes next.
There may be possible mitigating circumstances. Do you understand that?
Huh? Nope, I don't.
You don't know what mitigating circumstances are? Again, that's another reason why you need to have
3 years, man. That's
I'm sorry?
3 years. That's nothing.
Let me tell you something. If, when I'm talking, you do not talk over me. Do you understand that?
Yes, sir.
You're not going to misbehave in my courtroom. You're not going to misbehave in front of this jury, because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
It's 3 years.
Well, you're the one that's elected to go with the jury trial, so you keep on saying it's only 3 years. That's fine. All right.
You try to give me 2 of it anyways. Might as well go to trial.
Okay. You understand, and I've told you several times now, if you represent, you will be detrimental, it will be detrimental to your case. You understand that?
I don't know if I believe that. That's your opinion.
It is my opinion, and I'm strongly advising you against it. But you understand that in my opinion, if you represent yourself, it will be detrimental to your case.
Everybody's entitled to their opinion.
Okay. But you understand what I'm telling you?
Yes, sir.
All right. And you understand that if you represent yourself, you're going to be held to the same standards as any other defense attorney and the same standards as I'm going to hold Mr. Arnold. You understand that?
Yes, sir.
Have you ever represented yourself before in any criminal prosecution?
No, sir.
And you wish to go forward today without the assistance of an attorney?
Oh, can I get a few minutes? I use the bathroom anyways.
A few minutes for what?
To use the bathroom, think about it, make sure this is what I want to do.
Take him to the bathroom.
At this point, it almost feels staged-like. Seriously, how does this guy even come up with this nonsense? First, he insists on representing himself, and now suddenly he wants to think it over. Yeah, right. It's giving pure stalling energy. Be real. Do you guys think he's actually being sincere, or just trying to buy more time? Because if I were the judge, I'd be side-eyeing the whole thing. It's wondering if this guy's trying to pull something shady, or even make a run for it. Let's not forget, this is the same dude who held up a gas station, got hit with a 10-year sentence, and still acts like an extra 3 years is no big deal. Major red flags. He's reckless, unpredictable, and honestly feels like a ticking time bomb in a courtroom. Let's dive back in and see if he keeps playing games or finally faces reality.
Can I say something real quick, Your Honor? I ain't getting that opportunity to use the bathroom. Your officer wouldn't allow me to come out the cuffs. I don't know how I'm supposed to. I don't want to be rude or crude. Like, I know I got off to a bad start with you, sir, and that's not what my intentions were. I'm just kind of obnoxious. I'm sorry.
Yeah, I'm not in charge of security here, Mr. Jones. The
So
deputies and the transport officers are in charge of your security of this.
How I'm supposed to use the bathroom in
Sir?
cuffs? How I'm supposed to be able to wipe myself in cuffs?
All right.
Your officer refused to move the cuffs when I was locked in the cell. I'm just trying to use the bathroom. I need to use the bathroom before we get started, sir.
Rhodes,
Yes, sir.
what's the issue with him?
I was never asked to remove the cuffs.
She was, man. You know I had to use the bathroom. I don't know what else I'm supposed to say. I need the cuffs.
All right, let's get through this and we'll talk about your bathroom after that. All right. I advise you that you're charged with an assault of a corrections officer as an inmate at the correctional facility. Maximum penalty, as we've said, is 36 months in prison. After closing arguments, I will give the jury the instructions of law. Now, the issues that present themselves with regard to you representing yourself, obviously, is a logistics issue since you are incarcerated. The shackles on your legs will remain. The court is going to make a finding, and again, if you want to have a hearing on this, Mr. Arnold.
Your Honor, I just asked the court to take note that he's previously been convicted of assault on a corrections officer and is an inmate incarcerated for offenses of violence.
So I'm going to make a finding that you pose a security risk to this courtroom. So the shackles on your legs are going to remain there. Now I'm going to accommodate you in that both the state and you will do your opening, your voir dire, your opening, the questioning of witnesses, and your closing arguments from counsel table. Now you can stand up at that table without your legs being seen because for the record, there's a skirt or the bench itself in front of you hides your feet. No one can see your legs. You understand that?
Yes, sir.
All right. So I've already told you that in the court's opinion, representing yourself is probably going to hurt your case, right? You understand, and I've said to you already that the state of Ohio is represented by a competent, experienced trial attorney. and that you will be held to the same standard as Mr. Arnold. You understand that?
Yes, sir.
All right. The rules of evidence and rules of procedure, even if you don't know them, will apply to you. Do you understand that?
Yes, sir.
I cannot assist you at all during the course of the trial.
Yes, sir.
You want to again understand that this is not a license for you to abuse the dignity of this court.
Yes, sir.
There will be no appeal for ineffective assistance of counsel.
Okay. Yes, sir.
Again, how old are you?
38.
How far did you go in school?
Dropped out.
So are you able to read and write?
Yes, sir.
I'm not going to lie. I really thought this guy was about to say he couldn't even read or write. That's how lost he looks right now. Do you guys feel even a shred of sympathy for him? Maybe he had a tough life. Maybe things didn't go his way, but come on. That's no excuse to act like this in court. You'd think anyone with common sense would know this is not the time or place to play dumb. And honestly, he's not even your standard sovereign citizen. He's worse. Arrogant, rude, and completely clueless. The man's facing 3 years in prison, and he's treating it like a joke. At this point, is he just sabotaging himself? Or does he genuinely not care anymore? Because if he catches another charge while locked up, he's probably going to laugh it off like a, what's a few more years? Unreal. Let's dive back in and see how this verdict turns out.
Are you on any type of medications or drugs?
No, sir.
Do you have any prior experience in representing yourself?
Not representing myself. I've always had good dialogue with my attorneys.
Okay. Do you have any prior experience, your prior experience in the legal system?
Just being charged with stuff.
Okay. You don't have any formal training in the law?
No, sir.
And you have no mental deficiency or conditions that would interfere with you understanding what's going on here today?
Not that I'm aware of.
All right. Now tell me once again, is it your intentions, is it your desire that you want to proceed in this trial representing yourself?
I'm pretty sure.
No, you got to be certain.
I mean,
Why don't we do this? Why don't we do this, Mr. Jones? Let's start. Let's allow Ms. Martin to represent you, and if something happens and you can change your mind later. It's easier to go that way than to go the other way. You can't have it both ways. What's that?
Can I use the bathroom, please? I really gotta go, sir. I just need to use the bathroom. I'll be a lot more focused and stuff. I really gotta use the bathroom.
All right, Rhodes, take him to the bathroom. I'm not going to go over this with you again.
That's
You have this
fine.
one last opportunity.
I understand, sir.
All right. Take him, let's go off the record. All right, we are back on the record in the state of Ohio versus Aaron Jones. Mr. Jones, you've had your second trip to the bathroom now. I take it everything went better?
Yes, sir.
All right, now, you have in front of you a form called Waiver of Counsel. I've gone over with you all of the elements of granting that waiver. Do you still wish to proceed as your own counsel?
I need to get some counsel. I need real counsel. I talked to my family. They was talking about hiring a lawyer. I thought it was a little more cut and dry. I had a little more confidence in Miss Martin in that. And just at this point in time, I'd rather just wait on my family to get a lawyer for me.
But that's not going to happen. This case is proceeding to trial today.
Well, I'll represent myself then.
You want Miss Martin
No,
to...
I don't want her near me, around me, or none. She can leave.
All right, sign the form in front of you.
What's the date?
Today's the 18th. All right, Ms. Martin, you'll stay behind Mr. Jones as standby counsel. Mr. Jones, you have, that's your signature, sir?
Yes, sir.
And you read this document?
No, not really. Why is Miss Martin here?
Because I'm making her a standby counsel in case there's an issue. She'll be in the back of the courtroom.
I don't need no
Mr.
help.
Jones, I don't care what you want with regard to that. I'm following procedure, and this is what we're going to do. Read the form, please.
The whole reason,
Mr. Jones, read.
Of representing myself was because I didn't trust the lady. That was the
Okay,
whole purpose of
she's
that.
not,
But she's still here and attached to my case. That's the
She's
whole
removing
purpose of
herself-
removing her was for that. Was for me to be able to represent myself.
You will be. Sign the form.
This
Read
form was
it.
already signed. You
All
already
right,
see
read-
my
read-
signature. You already
I'm sorry, I
asked me my
misspoke.
signature. You see my signature was on that shit. You already said it was there. What are you talking about?
I seriously can't believe how this guy's talking to a judge right now. Like, zero fear, zero respect, just pure attitude. And the craziest part? He's this scrawny dude trying to act like he's the toughest guy in the room. Bro, who are you trying to impress? The judge isn't flinching. The courtroom isn't buying it. And honestly, neither are we. At this point, I can't tell if he's completely delusional or just numb to reality. Maybe he's so used to prison life that another 3 years doesn't even faze him anymore. What? And that's actually kind of sad when you think about it. Still, it's wild to see him act all bold when everyone can see straight through the act. What do you guys think? Is he really that confident or just that lost? Let's dive back in and see how this all plays out.
Jones, read the form. You said you
I already
didn't read
signed it, man. It's cool. Go ahead.
Read the form. Are you able to read and write?
Sometimes. Depends on how many pictures are on.
You done?
I ain't read it. I
get
already
the form.
signed it. We already went over it. It's cool.
All right, the court will make a finding then, sir, that you've made a knowing, intelligent, and voluntary waiver of your right to counsel, and the court will accept that. Ms. Martin will stay in the courtroom as standby counsel. Other than
I'm
that, are we
objecting
ready
to
to...
Ms. Martin to stand by counsel.
Mr. Jones, I'm going to tell you one...
counsel.
Mr. Jones, I'm going to tell you
I'm not
one...
allowed to object. I'm my own counsel now. I'm allowed to object, ain't I?
Then you say the word objection.
I did. I said I object.
What are you objecting to?
I'm objecting to Ms. Martin stand by as counsel. I'm representing myself. I'm objecting to having her here. I don't trust her. So that's the whole reason of me releasing her was to represent myself because I didn't feel confident with her abilities, nor did I feel confident enough with her not working with the prosecution in order to help lay down and obtain a conviction. My removing of her was based on...
Stop. Your objection is overruled. Ms. Martin will stay in the courtroom as acting counsel. Standby counsel, sorry. All right, are we ready to bring the jury down?
Yes, Your Honor.
All right, bring them down.
So here's the wild part. We didn't actually get the jury trial footage because, of course, cameras aren't allowed during that part. But according to court records, this guy went all in, represented himself, and ended up getting exactly what he asked for the full 3 years. And just to be clear, that's consecutive, not concurrent, meaning those 3 years stack on top of his current 4-year sentence. So yeah, he's looking at 7 years total now. Honestly, that probably explains why he seems so calm. He must have thought the sentences would run at the same time. Too late for that realization now. What blows my mind is how confident he was walking in, only to end up making things so much worse for himself. Do you think reality's finally hit him? Or is he just too far gone to care? Either way, this case is definitely one for the books unforgettable, but for all the wrong reasons. Let me know your thoughts in the comments. And if you enjoyed the breakdown, make sure to like, subscribe, and stick around for more courtroom chaos. Thanks for watching, and I'll see you in the next one.